Director of the ARC Michigan. Hi, Sherry.
Hi, Emily. Thank you. As Emily said, I'm the director at the ARC Michigan, and I want to thank everyone for attending the second session today. We have David Goldfarb from the ARC of the United States. He's the director of long-term supports and services at the ARC. Before he was working at the ARC, he spent nearly 8 years at the National Academy of Elder Law Attorneys, where he oversaw their advocacy initiatives. He currently co-chairs the Disability and Aging Collaborative and the Consortium for Constituents with Disabilities, Financial Security and Poverty Task Force. He began his public policy career as the Economic Policy Fellow for Senator Bill Nelson of Florida. Thank you, David, for being here this morning.
Thanks so much, Sherry. I really appreciate it. The work that everyone does at the state level to advance both state policy and federal policy is so important. So I'm really happy to be here today to speak to all of you. So I'm going to give a federal policy update, and we're going to talk both about a Supreme Court case, some legislation, and also some regulation that is going on in the space of both long-term supports and services, as well as some Social Security items. So the biggest news to come out yesterday was the Supreme Court ruling and what's known as the Talevsky case. This case questioned whether individuals should have a federal private right of action to sue states for violations of Medicaid law. And we were very, very nervous that that right would be taken away. But in fact, the opposite happened, which is to say that the Supreme Court reaffirmed a federal right, private right of action against states in the federal courts for violations of Medicaid law. This is really important. I'll just give you an example that when I was with the elder law attorneys, when states would violate Medicaid eligibility requirements in federal statute, the way in which they could get states into compliance was through lawsuits. The only other option would have been CMS, which is the federal government, the Centers for Medicare and Medicaid Services, trying to get the states to get in shape. A couple items, since I think this is my first time speaking with this group, so I wanted to go all the way back. Now it seems like a long time ago to the end of 2022, just to highlight some of the key things that the ARC worked on as part of that end of year package, and we're really happy we got. The first is extension of what's called the Medicaid Money Follows the Person demonstration project, and we were able to get an extension through September 2027 for 5 years. This program is what allows states and provides grants to states to get people out of nursing homes and ICFs and back into the community, both in terms of individual supports like first month's rent or finding furniture, but also in terms of the infrastructure that the state can have, like a housing coordinator and someone who can help people locate places in the community. Before then, I think really since about 2018, we had been going through these very short-term extensions of this program, and states really, because of that, stopped using it. Our hope is that states will ramp back up the Money Follows the Person program, given they have now 5 years worth of funding and 5 years worth of authorization. It's gotten over 100,000 people out of nursing homes and other institutions and back in the community. So that's a really important item. The second is our long work with the broader disability community on getting the ABLE age raised to before 46, and that will start in 2026. When ABLE was first conceived, it was supposed to apply to all people with disabilities. Because of the score, which is the cost that the Congressional Budget Office thought it would be in 2014, to come to a compromise, they limited the amount you could place in an ABLE account, and they reduced the age to 26. This is going to allow a lot more people with disabilities who are working to get access. It'll also help stabilize and shore up the system. Right now, I believe there's about $1 billion throughout the states in terms of assets under management for ABLE accounts. And of course, states have to self-finance through the fees they charge with these ABLE accounts. So the more people that we can get, hopefully the lower or the less risk that states will need to raise fees in order to keep their ABLE programs going. Finally, we have worked, I believe, for decades on one school in Massachusetts that uses as an aversive electric shocks. I believe the UN has labeled this as torture. To my knowledge, this is the only place in the country that does it. It may even be the only place in the world. There was an FDA, the FDA attempt to regulate it out of existence. There was a federal court case, which they won, which the school won, excuse me. And so it continued. We made a very good progress in terms of trying to get it banned outright, but the final deal just basically punted it back to FDA to create a pathway based on that federal lawsuit that would allow it under the law or a new law to actually ban this device. And so my colleague Robin Linscott and others are working with FDA right now to try to get that regulation out. The other big item that happened, and I know you're all in the middle of it right now, is the end of the public health emergency. And of course, as you probably all know now, that every Medicaid beneficiary will need to go through a redetermination, but also that the Medicaid programs and benefits and services may be changing in your state. I don't know what, for example, what your Appendix K waiver had, but things like paying family caregivers became very popular. Telehealth became very popular. There were retainer payments for direct care workers that were used, a whole array of things that different states could pick from. Many of those things can remain and are optional to states. This was just an easier pathway to do it. And so a lot of states are looking at whether or not they should continue those programs. So in terms of big congressional deadlines, we've just passed one of them, which was the June 1st debt ceiling, which we'll talk about. And that was a real big one that was driving a lot of policy. The next one will be September 30th. That's when the funding, the appropriations bills will run out. There's also what are called disproportionate share hospitals within Medicaid. So these are hospitals that have a disproportionate share of Medicaid beneficiaries. They get some boost in their payments from the federal government. If the federal government doesn't act, those extra payments will be cut. That is a possible area of policy, you know, so we will have to watch. It doesn't seem like anything bad. Usually we worry about what are called pay-fors. So to offset government spending, they have to negotiate similar cuts in the program. That doesn't seem to be the case right now, but we'll be looking very closely at that. And the final one is the Farm Bill, and the Farm Bill includes SNAP, which is sometimes known as food stamps. And again, everyone who's on SSI is categorically eligible. It's not something that we talk about all the time because it's really like every 5 years that SNAP comes up. This happens to be one of those years, and that's something that we are getting involved with, making sure that that there are no harms to the disability population and others as part of that Farm Bill. And then finally, as we'll jump into about the debt ceiling, April 30th will be when Congress, under this deal, needs to have 12 appropriations bills done. Otherwise, there's going to be some automatic caps put in. So that's another date that could really drive potential policy. Generally, as what happened in the end of year package, when Congress does a lot of appropriations bills, they put it in one package, but then there's what are called policy riders. Policy riders are, frankly, the stuff we tend to work on, which are things like Medicaid, things that are not appropriated dollars, but are policy changes to entitlements like Medicaid or Medicare. Not as much Social Security, although that could come up. So what was in the debt ceiling agreement? the first thing I want to say is thank you to all of you who reached out to say no to Medicaid cuts and no to Medicaid work requirements. We were able to keep that out of the package. I know we got the ARC alone over 80,000 contacts to Congress. And not every program was spared. SNAP did see a work requirement increase from ages 50 to 54. They have a work requirement in there. And this Medicaid work requirement, the text frankly shocked me. When you look back at what were called the Section 1115 waiver battles, the Section 1115 waivers are essentially, you have the federal statute and states must agree to comply with the federal statute in order to get the federal funds for Medicaid. And then you have what are called waivers. So for example, 1915C, your home and community-based services waiver, waives the nursing home mandate and says we're going to provide people that qualify at institutional level of care at home or in the community. That's a waiver. There's another waiver program that's for demonstration projects. Many states use it. It allows states and the federal government to come to kind of an agreement to rewrite the federal statute. It's kind of like a contract if you think about it. So they're rewriting the contract. Generally, when states sought to apply work requirements in those contexts under the Trump administration, it only applied to what's known as Medicaid expansion. That's that low income health insurance program that was created under the Affordable Care Act. This didn't do that. This applied to every single pathway and eligibility category for Medicaid, including people on SSI or home and community-based service waivers. It applied it entirely to everybody. And then if you were a person with a disability, you would have to get a doctor's note to say that you were physically or mentally unfit for work. This is a major work disincentive for people with disabilities. It is not in line at all with what are known as the substantial gainful activity rules in SSI and SSDI, because many people, of course, do want to work, but it's the fact that they're limited. And so it would have created a lot of red tape, a lot of clarity, and a lot of people would have gotten kicked off as a result. They also said, well, don't worry, we'll take care of caregivers as well. But they used the term incapacitated. Now, that word does not appear anywhere in the Medicaid statute. I'm only familiar with it in the guardianship context, which is that someone who is unable to communicate or make their own decisions as determined by a court is deemed quote unquote incapacitated. So theoretically, based on that interpretation, for example, someone with quadriplegia would not be someone who's incapacitated, therefore the caregiver would be disqualified and that wouldn't count towards the work requirement. So we successfully got that out. And so thank you so much for everyone who advocated on that. Overall, I would say that politically, the debt ceiling was the best we could really hope for. But of course, the status quo right now is not good. So it really depends on your lens. Right now, what are called non-defense discretionary spending has been systematically underfunded for a long time. And so that includes things like affordable and accessible housing, like housing vouchers. Many of you who understand, who have tried to get vouchers, understand the wait lists. It includes IDEA funding. It includes the underfunding of the Social Security Administration, which is at its lowest staffing levels in 25 years. So when you hear complaints, why did the Social Security office mess up? Why did I get a notice 12 months later about an overpayment? Why can't they keep track of anything? Part of it is systematic underfunding over decades. And so we really need some additional spending in those categories. But this sets caps. It'll set the what's called the FY 2023 level. So the current fiscal year from September 2022 to September 2023. That will be the funding level for 2024. So there won't be any adjustment for inflation. And then FY 2025 will be at a 1% increase. So really holding back against inflation. And of course, there are wage, meanwhile, you have step increases for government salaries adjusted to inflation. You have the fixed costs of certain capital like IT going up. So it is in effect a cut to non-defense discretionary. Non-defense discretionary, again, is really a whole range of programs under the sun that are not entitlements. So anything that's not Medicaid, Medicare, Social Security, SNAP is a bit of an entitlement. There are certain grants to states that are kept out, but things like housing, IDEA funding, vocational rehab, funding for the administration on community living, all those are technically non-defense discretionary. So that's what we're talking about. So what's next? Well, so they have this agreement for the caps. And then Congress said, well, we have by April 30th, 2024, we need to come up with an appropriations bills, all of them. And if we don't, defense will get capped too. So it's a major incentive to develop appropriations bills. So the way it works is that we have this overall level of funding of how much the government can spend. And now you're going to have a big fight within those appropriations bills about how much gets allocated to what, and then within each appropriation bills, how much gets allocated to different programs. And of course, it's a much smaller pie. For example, the Social Security Administration competes for funding with NIH. NIH has a lot of popular support because it's trying to cure things like cancer. There's a lot of pharmaceutical interest in public research so they don't have to do it basically, and then they can commercialize it. And Social Security doesn't have a very big constituency that's active in lobbying, and so that's a concern moving forward into these appropriations bills, that something like Social Security could not only, it may not just be that 1%, it may actually be a cut compared to where they are now, depending on how that smaller pie gets cut up. And I talked about the proposed Medicaid work requirements already, which is here. So I joined the ARC in March of 2022. When the opportunity arose, I had to jump on it because it's just such an amazing organization, and an amazing community, and an amazing network. So I'm really happy to be part of it. I started off doing SSI policy, and then I joined and switched portfolios at the beginning of this year. One of the things that has really surprised me about the current state is that I mean, we know there are 650,000 people on wait lists, but that the workforce shortage is such a crisis that it almost doesn't matter, because if you got off the wait list, there may not be anyone there to provide you with the service. And so it's the basis for so much of our work right now, although as we'll talk in a little bit, we're in a bit of a complicated situation with a proposed rule. But it's really been about, since I joined, trying to address the workforce shortage and focusing on how to increase direct care worker wages. And basically nearly every state is reporting shortages. One smaller item that's bipartisan that we are still hopeful perhaps this year we can get through deals with what are called the standard occupational classification systems. So the Department of Labor collects a ton of data on different professions and different work. And when states hire consultants to develop their rates for Medicaid, they make use of this standard occupational classification system. So this is what allows, for example, them to say, okay, what is, let's say the median worker making for as a personal care assistant, and they can look, and then they can tweak from there, the presumed wage that gets put into a broader payment rate. For us, one of the big things that is missing is that there is no separate code for direct support professionals. They sort of fall into this double category. There are sort of these two subcategories of personal care assistants and home health aides. We are working with the DSP National Association and ANCOR to try to make the case that we need this because it will allow the collection of better data and will help states set rates better and ideally, hopefully, raising it. Given that their work is beyond just typical personal care, but about training and teaching someone how to be independent in their communities. So that does have that is bipartisan, and we are working through it. I think the agency itself is not thrilled because this is normally done through a notice and comment period at once every 5 years. So even with that pushback, at least we can set the basis if we can't get it through Congress that they feel that they need to do this next go around. Right now, a lot of states do what's called blending to get a DSP wage within a rate. So they, take, okay, what do they do when they take these little pieces and put it together? There's no real coherent way in which these rates are setting or assuming wages for direct support professionals. Then there are the two big sort of exciting bills that we are working on. One is called the Better Care, Better Jobs Act. That relates back to the reconciliation package that I know so many of you worked on to try to get a major expansion of home and community-based services in the last Congress. And so that one is very much based and founded on that model. And so the way it works is that states have the option, would have the option of taking this up. And in exchange for a 10% federal match, which when you do the math, it's way more than 10%. So 50% is sort of 1-to-1. So there's a math equation. You get up to 80%, you're at like 3-to-1. So it's a huge bump for home and community-based services if they took it up. They would have to strengthen and expand HCBS, expand the workforce, show improvement, maintain where they are. This is estimated to cost $300 billion over 10 years. So it's clearly something that's not going to happen this Congress. But we were extremely pleased to see that I believe 40 Democrats in total signed on to the legislation. The second one that I think is the most exciting for us and will be really the long-term goal to solve, which is the HCBS Access Act. And that would mandate home and community-based services as a benefit under Medicaid. So this, unlike the Better Care, Better Jobs Act, is not a state option. States would have to do it. It would help alleviate, for example, portability issues. And in this draft, because again, we're shooting for the moon and we're putting a stake in the ground, states would receive full federal funding. So it would also basically federalize the funding for home and community-based services. And we're working on getting more co-sponsors for that. We're also anticipating something really exciting that happened last year to come back, and that's that proposed bill to increase the SSI asset limit on a bipartisan basis. That was known as the SSI Savings Penalty Elimination Act. And that was introduced by Sherrod Brown and Rob Portman. We're hopeful that with Rob Portman of Ohio retiring, it appears that Senator Cassidy of Louisiana will be stepping in his place as the Republican. When I started doing SSI policy at the ARC, and this happened maybe 2 months later, it was almost unimaginable that we could have a bipartisan bill on asset limits. The fact that we do and that has continued into this Congress is incredibly exciting because it means that, yes, it might take years to do, but it makes it a much more realizable goal that both Republicans and Democrats realize that we need to raise the asset limit. The current asset limit, I think, as most of you know, is $2,000 for individuals and $3,000 for couples, and it does not adjust for inflation, and it's been stuck there since 1989. The proposal would raise it to $10,000 for individuals and $20,000 for couples and adjust for inflation. Another bill that, and my new colleague who's taken over, her name is Darcy Milburn. She's handling our Social Security SSI policy as well as healthcare. I've retained ABLE accounts and special needs trust because of my work with the elder law attorneys and my knowledge in that space. So I still retain that part. But work without worry is something that she's working on. Again, another exciting bipartisan bill. You have this issue, a small issue, but when it impacts someone, I shouldn't say it's a small issue. A small number of people are impacted, but when they're impacted, it's a major disruption in their life. And that is, again, there is a benefit known as the disabled adult child benefit. When your parent pays into Social Security through payroll taxes, if they themselves go on Social Security disability insurance, if they die or if they retire, and you have developed a disability before the age of 22, you can qualify for what's called a disabled adult child benefit. The benefit of this benefit is, number one, it's typically higher than the typical SSI benefit. And number two, after 2 years, you get access to Medicare. And so that can open up a lot of good providers on the acute health side with its much broader networks. The problem is that if someone was working and wanted to work before a parent died, became disabled or retired, and they went over substantial gainful activity, which is the level at which Social Security effectively says you don't qualify as having a disability under our statute because it's so related to work. Right now, I believe it's a little over $1,400 a month. If you ever went over it once, 1 month in your entire life, you can never qualify. The other benefit of a disabled adult child benefit is that if you were on SSI first, you can maintain your Medicaid eligibility. So you can get that income increase, you can get Medicare, and you are not at risk of losing your Medicaid. Another big theme that we have worked on is marriage penalties. This is one that has gotten a lot of interest, and I think is sort of some of the cutting edge of the disability rights movement, which is to talk about the right to marriage and the disincentives built within the statute that prevent people from getting married. When I talk to our self-advocates, this is one of the issues when I came on Social Security that they raised immediately. It impacts people not just when they have found someone and want to get married, but even before. It's a dehumanizing experience as someone comes of age. They become a teenager, turning 18, and they want to live their life independently, and they realize that they can never really get married, and that in their life, a part will have to be unfulfilled as a result of these penalties. There are a couple of them within the Social Security statute. If you get married and you're on SSI, there's a 25% cut in your benefits and to the combined asset limit, that instead of 4,000, 2,000 times 2, it becomes 3,000. And of course, these benefits are so incredibly low, combining them and what economists would see as the efficiencies of living together. You buy 1 microwave instead of 2 microwaves. It doesn't really add up at all, given how low the benefits at all. So many people won't get married. There are rules around when an SSI beneficiary marries a non-SSI spouse. It's called spousal deeming. It deems some of their assets and income available and can kick the person off. And then within the disabled adult child beneficiary group, if they marry someone who's not what's called a Title II beneficiary, that benefit ends. And unless you get the marriage annulled, you can't get that benefit back. Divorce is not good enough. And so that includes someone who's on SSI. And so many people we find age into the disabled adult child benefit. Then they find someone they want to meet. That person is on SSI and they realize that they can't get married without risking losing their disabled adult child benefit. And again, if you lose that, you lose Medicare as well. And of course, I'll just say, another ongoing issue, of course, is work. The fact that people want to work, but that limits such as substantial gainful activity make it difficult to work. So that's something that we're always working on and looking at. A number of big regulations are coming out. We're really sort of at the tail end of the administration trying to get out as many regulations as they can. There's something called the Congressional Review Act, and this happened when Trump took office and overturned a lot of Biden's regulations. It gives the right of a new Congress to look back. It might be like 60 legislative days. I can't remember the exact date, but it gives them the right to look back at agency actions before. So the fear that the current administration has is that if we have the House and the Senate taken over, if we have Trump 2.0 or DeSantis or Tim Scott or anyone else who's running, that the regulations that they finalize will be overturned. And once they're overturned, it becomes much more difficult to pass them. So they're really trying to get a lot of big regulations out right now so that they can finalize them before that cutoff date. One exciting one is in the realm of SSI policy, and that's the proposed exclusion from in-kind support and maintenance of food. When you have, when you're on SSI, your income counts against your benefit. You have earned income like wages, which is about for every you have an income exclusion, but then it's about half are excluded. You have unearned income like a pension that might be coming in, like a survivor's benefit that might be coming in, that reduces it 1-to-1. The statute also has what's something called in-kind support and maintenance. And that's basically when you get something for free or for less than fair market value that provides for your support and maintenance, then that counts as income and you would have your benefit reduced. SSI beneficiaries can see their benefit reduced by 1/3. Prior SSA regulations had gotten rid of clothing, but we still have food and rent in place. Rent is obviously the big one, and it's the one that I don't think that they're going to be able to get rid of regulatorily. I think that one, that would basically end the statute itself, and SSA can't do that, but they can end food. I think the biggest benefit of ending food from in-kind support and maintenance is not that there are a bunch of people who are just getting food and also not rent. Typically what we've seen, particularly since COVID, is many people moving, say, out of a group home and back home, for example, and then they get their SSI benefit reduced. But now people don't have to be afraid that their parents, bring them a meal, they go to McDonald's, they take them out to a Chinese restaurant, and suddenly you're worried about how is that going to impact SSI, and that will all go away. It'll also give more flexibility for trusts, because again, trusts might be hesitant to pay for food since it would reduce the benefit. And so for those who are looking at planning around trusts, that can be a benefit. I'm also hopeful that Social Security is going to come out with a broader exception to the in-kind support and maintenance rules around what are called households on public assistance. Right now, under the regulations, if you're on a cash public assistance benefit, the entire household, everyone in it, then in-kind support and maintenance is not counted. And Social Security is looking at expanding it to broader categories, things potentially like SNAP. The reality is that Social Security does not like in-kind support and maintenance as much as we don't like in-kind support and maintenance, because it's an extreme administrative burden to ask all of these questions of beneficiaries, and it takes a lot of work and paperwork. And as I've said, they're completely underfunded. So to figure out who's buying whose groceries for 8 million individuals is just a headache. So this is something where we're actually pretty aligned with the agency on. Of course, many of you saw the Biden executive order on care. Overall, there isn't a lot of teeth to it. I think what's most exciting about it is that he's raising these issues and is trying to bring some national attention to them. I'm in the middle of responding to some, as well as my colleague Darcy Milburn, major Medicaid regulations. One is called Ensuring Access to Medicaid Services. That's the one I'm focused on. And the other one deals with managed care. The managed care one does not appear to have as much around home and community-based services or services that people with IDD really rely on. So it's less impactful for our population, but the Ensuring Access to Medicaid Services is a very big one that is heavily focused on home and community-based services. It does a number of good things, and then there's one small piece that we have some concerns about. One is that it's going to require states to have a lot more data reporting on wait lists and payments. It's going to require states to do at least once a year a reassessment of a person-centered plan to make sure that everything is up to date in terms of what people need. They're going to have to implement an incident management system. They're going to have to establish a grievance process. They're going to have to report more on standardized quality measures. There's going to be some improvements around these advisory panels, as well as the creation of a beneficiary advisory group to advise the state on the services and rates it needs. Finally, they wanted to do a good thing, but unfortunately, they did not apply the or they don't have the data analysis, and they picked far too high of a number, and so we're very concerned about that. And the idea is that there would be some kind of pass-through from a payment. In this case, starting off with homemaker, home health aid, and personal care services to spend on compensation for direct care workers. Now, everyone I know, and I can say for myself, is working to improve the wages of direct care workers. But unfortunately, CMS did not look at payment rate studies. They conflated what we fought for in terms of getting increases in payments and having a pass through there with overall payments. And unfortunately, when you run the numbers, states kept the payment rates the same, and CMS really can't force states to raise the payment. You would have catastrophic cuts to administrative costs, and the traditional agency model, again, based on our analysis, and CMS doesn't have their own, would effectively cease to exist. So I think their intent was to go high and then say we can always dial it back. But unfortunately, they have chosen such a number without data that would be fairly catastrophic. So it puts us, we want to make sure that they understand that we are committed to increasing direct care worker wages, that we believe in financial accountability of all agencies, but that they need to do a lot more assessment and analysis of what's needed, because part of this relates to the fact that rates overall are so low. I'll just give you one example, that in the state of Florida, they did something what sounds very good, which is that they set a minimum wage for a direct care worker at $15 an hour. The problem, as was relayed to me, is that one of the payments for services was less than $15 an hour. And so when you do something like this, the payment rate needs to match what is feasible. And that's not really here. And so that creates a lot of the problems. And so we'll be taking a deep dive in terms of how to better construct these and raising our concerns with the number they've selected. The ARC is also working on a whole lot more: affordable housing, healthcare, employment, criminal justice and crisis response, education, paid family leave. And so we have a whole great team. I also want to mention, and I'll just do quickly, and then we can open it up for questions. The reason that Congress and regulators and others listen to me is because of you. Because we have a network of over 600 chapters, because we have hundreds of thousands of advocates, self-advocates, people with disabilities, family members, workers, you name it, behind our cause and working together. Without that network and without what you do, Congress would be much more unlikely to listen to what we have to say. And so your work and your advocacy on the ground is critical. Your stories are extremely powerful and extremely important. We have someone completely dedicated to collecting those stories and sharing them. I was blown away when I was working on SSI that in one story collection, we got over 500 stories. And those stories also not only help Congress understand it, but they also help us understand what's really happening on the ground. Our job is ultimately to take the information about what's happening on the ground, look at the law, look at what Congress is doing, and try to translate that for them. So your stories are impactful, not just to Congress, but to us, so we know what is happening and what the trends are. I recommend all of you, if you haven't, to go to the arc.org/action. That's where you can take action, but you can also sign up for our email updates. And there are different ways to follow us. There's social media. We do a We Act Wednesday on social media every Wednesday to take some action. There are resources for the public health emergency. And you can even sign up for ARC texts. And that will all be in the materials because this PowerPoint will be shared with all of you. So with that, I'm happy to take questions. I have not had time to look at the chat. But I will look now to see what has been written. So I apologize. It looks like there may have been a lot. Let's see.
I'll read through the questions that I've seen so far for you, David. Our first is a comment about the direct care wages. It's disheartening. This person says she works with individuals attending college, and they're struggling because they're not able to secure a PCA. And this has the potential of causing them to drop out of college. And so this person says they're interested in whatever incentives and options that she can pursue for the person she's supporting.
Yeah, I think that there are two fundamental places where work has to be done. The first is the federal level, and getting states to adequately fund these programs for the vast majority of states is going to require additional federal funding. That's why it was so heartbreaking to see the Better Care, Better Jobs kept out. The second, though, is that you have to fight for these state resources. These wages are set by Medicaid in effect, and the payment levels provided determine how much someone's going to get paid. And Medicaid as a whole, not just home and community-based services, is extremely underfunded. And so really work with the ARC of Michigan to, as I'm sure they're doing, to take to the state legislature of the need for more funding. Without the funding overall, there cannot be higher wages.
Thank you for that. Next question, is there any current activity or talk about supporting Black grants or per capita caps for Medicaid, or is that proposal over?
So in DC, no proposal ever ends. I think the good news is that it was not on the table at all for this debt ceiling. And it is not on the table for this Congress. It was clear that when they proposed it last time, they probably bit off more than they could chew when they tried to do it in the ACA. But I do think that those ideas continue. They are out in the ether. They are not an immediate threat, but those conversations will always continue. And so, well, it's not the top item right now. We don't know where things will lead, so it will require another assessment. But the work that everyone did at the at your level, at the grassroots level, was vital to stopping it last time. And so we're ready for the fight. And I think we just showed them what happens if you try to cut Medicaid, which they tried to do by $100 billion in this, that there was an outpouring, that there was a united front, and that this is a true third rail of politics like Social Security and Medicare. And that's what we need to keep showing them.
Next question is about in-kind support and maintenance. Can rent be paid from an ABLE account?
Yes. So the regulations around ABLE was very interesting, in that the Social Security Administration said that rent out of an ABLE account does not count against in-kind support and maintenance. And in fact, one of the things that lawyers and planners have talked about is that if you have, say, a third-party trust, you can transfer it into the ABLE account first and then pay for rent out of an ABLE account. So that is something you can do, and it will not count against in-kind support and maintenance. I should say for now. Of course, the regulations or the guidance is always subject to change, but for right now, you can do that.
Thank you. We have next a comment and then a question about the rules around marriage. The first comment is that people are put at risk if they do not have the economic power to leave an abusive relationship. The follow-up question about the $2,000 limit and the married couples penalty. Does the current focus on these issues include elements of the recommendations from the Work Without Worry Act?
They are similarly situated in some sense, but they are separate. So first, there's a lot of crossover in terms of who's supporting them. What makes it a little unique is that SSI is, and the SSI Savings Penalty Elimination Act is part of one program, and the Work Without Worry Act is part of the Social Security program. And so the way that breaks down is that on the House side, they go through different subcommittees. And so although they're very similar, and it would be many of the same supporters, I'm not sure that they could be, for example, packaged together easily, at least on the House side.
Thank you for that information. The next question, can you speak a bit more about the 80% proposed rule?
Yeah, sure. So CMS is working in relation to this. They're also working on a nursing home staffing ratio rule, and that nursing home staffing ratio rule will also have a pass-through. The ARC and its chapters have supported pass-throughs, often at 80-20, as increases in payments. But you find that that in terms of overall payments, it's a little bit different. So I'll give you an example of a model I looked at. The model was in Virginia. I looked it up and did the research. Direct care worker compensation was about 72.5% of the rate structure. Then you had program support. So what's in program support? Program support is things like frontline supervisors who are often doing direct care, could be case managers, could be the training and onboarding. Then you have travel, the reimbursement for someone traveling to and from an individual. And then you had, and that was about 6%, and then you had about 11% for the overhead, the administration, the rent, the EVV, the mandates, the insurance, and all of that. And so you sort of have this in between of things that are go directly to supporting the beneficiary, perhaps around, well over 85%, but they may not fall within that definition. The trouble is that although I would like to believe that CMS can force states to raise payments without any additional funding, and therefore, theoretically, this wouldn't be an issue if I thought that CMS could force a state to raise their payment rates by 50%, so that the model would work out without costs, then I wouldn't be as concerned. Unfortunately, Medicaid is an optional program. The eligibility categories are optional, and for many of the eligibility categories are optional, SSI being a mandated one. And then the home and community-based services are optional, and we have wait lists. And so CMS's ability to force states to raise their payment rates are very limited. If CMS put the hammer down and said, you need to raise your payment rates, states could just cut and cap their waiver. And so say, everyone's going to be back with their family. We're not going to provide services, or they're going to be in an institution. CMS's options then would be to deny the waiver application, which is to say that nobody gets access to home and community-based services, or they can take away federal funding, which is totally counterproductive. But because CMS can't force states to raise payments, and because they selected a number that is far in excess of, although it seems like a small number difference when you run the math, it would in effect crush basically the ability of an agency to exist. It basically on the good sentiment and idea behind it, unfortunately, would end up reducing access and quality. And so it's kind of a creation of unintentional harm. So a lot of it is that how can they develop the analysis to perhaps do this properly? Another frustrating thing is that states will often do what are called rate studies. So these are where I'm getting these numbers from. And it says, you should be, we're assuming that you should be paying, say, $20 an hour, and that's going to be 75% of the overall payment. And then a state legislature will say, yeah, well, we're not going to do that. We're not going to fully fund it. And so what do you do in that case? So it's a very tricky situation, and little information exists. And unfortunately, the number they picked was one that would be very harmful. I think you'll see state DD directors likely to raise concerns, and others raising concerns with the number as well. The trouble is I'm not sure, for example, what a right number would be, and I'm not sure that the information exists at this point to make that determination. One of the reasons being that states have different mandates. So for example, Oregon pays great direct care worker wages. The average might be over $23 an hour, but they also have a lot of regulatory requirements, a lot of supervision requirements. So they pay great wages, they have great oversight and supervision, great training requirements. They would fail to meet this standard and they would have to cut as well. And so even great states like Oregon that pay good wages and don't have as much of a shortage issue would be hurt through this concept. And again, we all support raising direct care worker wages. It's just that this proposal would end up harming, not hurting, and would not help the situation because of the number they picked.
Thank you for that valuable information, David. Regarding the issue of people who received SSDI having never received SSI, the situation that they're sharing is that they have a family with an adult child who is a DAC with a large spend down. And the problem is that they can't access community mental health or HCBS because they have that much of a spend down. And so if you or Sherry have any suggestions on what you can direct them to next.
Yeah, I do. Well, of course, I have policy solutions, not practical solutions, which may require if you haven't spoken with an attorney. But this is absolutely an issue. As I mentioned, SSI, you get SSI first, and then you get the DAC benefit, as it's known, the Disabled Adult Child Benefit. DAC for short, you can get Medicaid eligibility. But if you get the DAC benefit first, you're not deemed categorically eligible. The important thing, though, to recognize is that the waivers that are applied for CMS can address this issue. So, for example, many of the DD waivers will check a box that says the SSI only level or SSI only. But other waivers, like the older adult waiver, you can become eligible at least 300% of SSI. In addition, when I was with the American Academy of National Academy of Elder Law Attorneys, we were able to get a rule of construction that gives states even additional flexibility to raise it. And so one of the ways to try to solve this problem is to try to work with states for the specific, I'm guessing in this case, the DD waiver. I don't know as much about, say, state mandated programs that may be outside of a waiver context. But at least within waiver services, you can try to work with states to fix that. My guess is it doesn't impact a lot of people. And again, the people it impacts, it's huge. But in terms of state costs, it might not be as much. Such that you can convince the state to expand eligibility to this population for the waiver. So that's something that that is worth looking at.
Thank you, David. We had another, I'm not sure if Sherry has a suggestion. I'll let her chime in a second. But somebody, another attendee has said that DAC beneficiaries in Michigan are not supposed to be placed into a spend down program. So might be able to follow up with Medical Services Administration on that question.
Yeah, it's yeah, the Medicaid eligibility, definitely varies a lot. And so it is true that they can get caught up in this program, but there may be options available. So this is one that may require an attorney or legal aid if you haven't, to speak with them about what some planning or options might be to try to solve the issue.
This is Sherry. What Brett says is true. Emily, if you can send these comments to Kathy McCrae and who they came from so she can reach out to them, that would be great.
Okay,
She's
perfect.
our WIPA coordinator.
And Sherry, tell us what WIPA stands for.
Work Incentives and Planning Assistance. It's a grant we have through Social Security, and Kathy just knows quite a bit about Social Security, so she'll be able to assist.
Okay, great. Thank you.
You're welcome.
we are at the end of our questions, and it's a little bit after 11:30. So thank you so much, David, for joining us today, and we have your contact information for
Yes.
follow-up questions. If you can progress to the next slide for me.
Oh, yes. There you go.
All right. So we look forward to seeing everybody back here again next Friday, June 16th. And we'll have a 9 o'clock session and then a 10:30 session again. And if you have folks who want to attend and didn't attend this week, registration is still open. I'll share this disability policy webinar series is offered at no cost, but suggested donation to the ARC Michigan of $25 is an option if you're willing and able, and I will share the link to that in the chat. So thank you, everybody, and have a great weekend. See you back here next week.